So I'm sure everybody's seen this Pineville trial update that our good friend, Mr. News Now Houston, Mr. Warden, put up. Okay, so he stated that it was a violation of the Pineville City Code. This is the Pineville City Code. It was 22-51, disobedience to police and fire department officials. I have no idea what the potential fines or jail time for this are. I have literally no idea. I called if you see here in their fee schedule, it says to see Pineville Police Department. You go to the Pineville Police Department and their webpage. It's garbage. So I actually called the Pineville Police Department, and I got what sounded to be a very fat Forrest Gump, who kept telling me, well, I don't know. I don't know what they charge you. I don't know if it'd be a misdemeanor. We don't arrest on city ordinances. No, we don't give citation on city ordinances neither. Well, it'd probably get whatever kind of fine or penalty the judge would order. I don't know. I don't know. That was a sergeant. That was a sergeant. Oh my God, what's going on down there? All right, so for the record, I think that Mr. Warden has a very good possibility of getting out of this. I would bet that this is just going to be like some sort of a fine situation, judging from the sound of things. But it's very hard to make that determination when you got fat Forrest Gump giving you the runaround and telling you to call the city prosecutor on Monday. So that said, here's my issue with what's going on with Mr. Warden. Mr. Warden is obviously acting as his own attorney, and I'm going to tell you why he's acting as his own attorney. This statement that he read, that he attempted to use as a motion to dismiss. First of all, motion to dismiss before evidence is presented has to be either based on the charges, like any indictment or any criminal complaint, be failing to allege all of the elements of the crime. That's one way. Or something else, something like on its face that makes it invalid. Beyond that, you don't have a whole lot of room for a motion to dismiss before any facts have been presented. Now, Mr. Warden has found an expert, a law enforcement legal expert. He calls him a legal expert, and he calls him a law enforcement expert. So I'm not terribly certain as to which it is. Apparently this guy is a retired law enforcement officer. However, there are so many problems with this. First of all, if you are going to introduce expert testimony, an expert has to be of use to the court. That's step number one. So if it all turned on, like, let's say, like the classic one is, is somebody gets shot with an ice bullet and killed with an ice bullet. And obviously the ice bullet melts. And so they bring in an expert on people who've been shot with ice bullets, who could tell you like the way the wound would look, who could tell you the way the ice would melt and how everything would work from that point, how long it would take the ice to melt, etc., etc. And then the expert would be able to make an expert analysis of the data to come to a conclusion, but not a legal conclusion. So the expert could say, looking at these photographs, looking at these forensic reports, it does appear that this person was or was not killed by an ice bullet. That's a statement of fact that normal people don't know what it looks like if someone gets shot and killed with an ice bullet. That's where an expert would come in. The expert can't testify as to what the facts were on that day because the expert wasn't there. The expert also cannot come to a legal conclusion. Where you classically see this is in the insanity defense. The expert can testify as to the level of insanity of the person, but not come to the conclusion that the person is or is not legally competent to stand trial. So trying to bring on an expert to testify as to A, what the facts were, and B, whether those facts add up to reasonable suspicion or probable cause, or whether there was in fact some sort of a violation of law or code or whatever, is completely inappropriate. Any determinations of fact are going to be up to the jury, or probably in this case a judge. It's probably not going to go. I'm assuming that this isn't going to be anything that's going to have much, if any, jail time associated with it. So I'm going to assume that there is not going to be a jury. But if there is a jury, the jury would hear the facts and determine what the facts are, whose testimony to believe and whose to disregard. And it's the judge's role. If there's no jury, the judge would also find fact. But it's the judge's role to determine the law. It's the judge's role to determine if there was probable cause or reasonable suspicion. It's the judge's role to determine whether or not a particular law applies or doesn't apply. And then, since I'm assuming the judge is the trier of fact and the determiner of the law, then the judge is going to apply the law to the facts and come up with a conclusion of guilt or innocence. Guilt or not guilt, I should say. So the motion to dismiss was poorly made, and Mr. Worden does not understand the law and probably has no business being in representing himself. He has no business doing that. However, if it is a very small fine, then there's no real harm in him representing himself, because he'd probably chew through more on attorney's fees than he would by just paying a fine if he loses. And it shouldn't be that hard of a case, but Mr. Worden should probably talk to like a paralegal or something, maybe guide him in the right direction. So I know everybody else thought that this was very compelling, but it was not. And the judge was absolutely right to disregard it. And because the whole thing was this guy trying to bring facts into evidence that apparently have not come into evidence yet, and making legal conclusions based off that evidence that isn't his place to make. So yeah, it was just a terrible motion all in all. Anyway, yeah, by the way, best of luck, Mr. Worden. Again, I don't think you're in a terrible lot of danger with this one. But yeah, I still wish you luck. Have a good day.